Did FDA act on its promise to regulate the vaping industry?
Yes, FDA issued its deeming rule effective on August 8, 2016. In fact, the deeming rule publication day was May 10, 2016. Before we start, let me just provide a disclaimer. Of course, the purpose of this webinar is to share some objective information about the deeming rule in FDA's own words. It does not mean that we agree or we endorse those statements as made by the FDA. As you may be aware by now, litigation has already commenced on this matter, so therefore we will not comment on any aspect of the litigation, nor will we encourage people to follow the rule in any particular way or to disobey the rule in any particular way. Finally, because none of the discussions herein should be construed to represent legal advice, I strongly urge you to seek your own independent legal advice for compliance with FDA regulation as well as with any other laws. So, FDA's rule purports to bring, among other vaping products, e-cigarettes, e-liquids, hookahs, as well as cigars and many other tobacco products under the umbrella of the Tobacco Control Act. As we elaborated in our previous webinar, in 2009, Congress adopted the Tobacco Control Act, which gives FDA primary authority over tobacco products. Because of the definition of tobacco products in the Tobacco Control Act, FDA now issued the so-called deeming rule, which seeks to extend FDA regulatory authority to cover new products, including vaping products. What the various outcomes of the various legal challenges will be in connection with this rule, we should not speculate. However, for now, we are trying to describe the rule in a very neutral manner.
Who has obligations under this rule?
Manufacturers, including importers, distributors, and retailers, have obligations. However, technically, manufacturers and retailers bear the burden of most of these obligations and will have to take immediate steps to comply with these obligations. The principal obligations rest with manufacturers, which also means importers, if the manufacturer of the respective product is located abroad. FDA can and will inspect domestic manufacturers and retailers once the rule is effective, and it will do so. In fact, on May 10th, Mitch Zeller has announced during one of his speeches at a conference that manufacturers are subject to inspection right after the effective date of the deeming rule, which is August 8th. In the past, FDA has announced inspections or announced starting the inspections, not individual inspections, and therefore we might expect FDA to make such an announcement in connection with inspections of newly deemed tobacco products manufacturers. The earliest compliance dates for a few provisions in this rule for manufacturers is August 8, 2016. Other provisions have a much later compliance date, as late as August 8, 2018. As of August 8, 2016, the rule requires that manufacturers do not change their products without FDA pre-market review. Also, manufacturers in the future cannot make modified risk claims, such as claiming that their specific products are safer or reduce risk, or having light, low, mild, or similar descriptors in the label and advertising of such products. If a manufacturer wishes to make a modified risk claim, a manufacturer may submit a modified risk tobacco product application and receive an FDA order before marketing products with such reduced risk or reduced exposure claim. However, to date, no such application was finalized or granted. By February 8, 2017, manufacturers must register a list of their ingredients with the FDA. However, this is a relatively straightforward requirement. It is extremely time-consuming. Bear in mind that FDA does not make the ingredients list public. Also, by the end of this year, the rule suggests that manufacturers should register a list of their products and provide a copy of their advertising to the FDA as part of the biannual product listing and registration. However, again, that can be cumbersome if a manufacturer has a large number of products. Again, FDA does not make public the list of products that manufacturers submit to the FDA. If a retailer is concerned that any of the product it sells is illegal, of course, there are mechanisms for the retailer to notify FDA, and then FDA can investigate. Clearly, in general, all manufacturer submissions to the FDA are confidential. There are many other compliance requirements in the statute that affect manufacturers, and we're just discussing a few of them, of course, the ones that are generally more visible, if you wish. The most important requirement for manufacturers of vaping products and e-liquids is the requirement to file an application to the FDA under one of the 3 pathways for pre-market review, and there are staggering deadlines for those applications. Because 2 of the 3 pathways require the existence of a predicate product that should have been on the market on February 15th, 2007, and because such products, to everybody's knowledge, did not exist, therefore it appears that for vaping products, the only available pre-market pathway is the so-called pre-market tobacco product application, or PMTA. And all manufacturers are required to file PMTAs by August 8, 2018 as a prerequisite to sell those products after that date. FDA is also granting an additional 12 months of a compliance period for those manufacturers that have filed a PMTA by August 8, 2018. So again, we're looking at a deadline that is in the future. However, given the complex nature of those filings and the confidential nature of the research that is undertaken in support of those applications, also the sheer volume of effort, do not expect manufacturers to file PMTAs much earlier than the deadline, simply because, again, this involves an extraordinary effort. There could be theoretical other alternatives for manufacturers to work with the FDA towards shorter deadlines, but we don't believe that those are available.
What about health warnings?
Indeed. The rule requires that health warnings on products be implemented 24 months from the effective date of the rule, which means that health warnings should be on the packs according to the rule as it is written now by August 8, 2018. And we're showing you on our slide what those warnings might be.
And what do retailers need to do?
Well, for retailers, again, compliance is easier, but it's more immediate. Retailers of the newly deemed tobacco product, including vaping products, may not sell these to individuals under 18 years of age as of the effective date of the rule. And as we know already, a number of states have implemented state laws that prohibit sale to underage persons. So to some extent, FDA rules completes or brings or reinforces that requirement. Of course, state requirements and federal requirements are distinct, and they have to be obeyed separately and distinctly. The rule requires retailers of covered tobacco products, as they're defined in the rule, to verify the purchaser's birth date by reviewing the individual's photographic identification that has also an indication of the birth date. So an example of that photographic identification would be a driver's license or a passport. However, a retailer is not required to verify the age of any person who is more than 26 years of age. Now, everybody will wonder, how am I going to know if a person is 26 or more? And a good answer would be, well, you should check their ID. In addition, the rule prohibits the sale of the covered tobacco products using an electronic or mechanical device such as a vending machine, unless this vending machine is located in a facility where the retailer ensures that no person younger than 18 years of age is present at any time or permitted to enter at any time, and this includes the retail staff. FDA does not intend to prohibit the sale of tobacco products via the internet, but the sale of covered tobacco products via any medium, including the internet, as of the effective date, must only be to persons 18 years of age or older. Therefore, any sale of covered tobacco products over the internet must comply with the minimum age and identification requirements in this rule. Retailers may choose any method of identification verification that complies with this provision. In the preamble to the rule, FDA specifically declines to adopt further recommendations for additional age verification requirements at this time. FDA typically will not give you a solution or will not recommend an age verification provider to retailers. Therefore, everyone must find their own solutions. Bear in mind that in addition to all the provisions of the deeming rule, there might be local and state requirements that are applicable to your product. And especially if you're a retailer, you certainly know them by now if they have been enforced for a while, and you should certainly follow the law at any time, whatever provisions of that law are applicable to you. It also goes without saying that retailers should not modify the products that they sell, the labeling of the products that they sell, simply because obviously if you tamper with a product, you may introduce changes to the product that FDA may enforce against. Also, it is very important to know that retailers who mix their own products in the retail shop. So for instance, people who mix liquids and then sell these mixtures on the spot to their consumers are classified as manufacturers, and therefore they must ensure they become familiar with the obligations that pertain to manufacturers. Again, I've only outlined a few of the obligations spelled out in the Deeming rule, and it is normal that everybody will have a lot of questions. Unfortunately, FDA doesn't always have the answers. More importantly, stay tuned, because FDA will provide, especially in the next few months, most likely a number of webinars and other information to retailers and manufacturers. You can also consult FDA's website under the Tobacco Products tab and look at past webinars and past guidance documents that refer to the tobacco products that have been covered by the Tobacco Control Act since the beginning, since 2009. While again, we cannot say that FDA will apply those guidance documents or that they will use the same information or the same type of information for newly deemed products such as vaping products. We believe it is a good starting point to read that information off FDA's website, because in all fairness, they have tried to answer, in particular for retailers, as good as possible some of the questions that the retailers had in the past. More importantly, please note that FDA will conduct inspections at retail facilities that may be anonymous inspections. Therefore, it may be helpful for you to look at the warning letters that FDA has issued in the past to retailers to see what exactly happened. The warning letters usually provide a description of the manner in which the inspection was conducted. You will see, for instance, that FDA would use underage people that will try to purchase tobacco products, and obviously under the supervision of an FDA staff or under the supervision of the locally contracted state authorities. FDA usually contracts with states to enforce the Tobacco Control Act in the various states. And you will sometimes read in these warning letters that the warning letters are issued at a much later date than the date when the inspection took place. So for instance, if you're inspected on August 10th, you might receive a warning letter after a couple of months. That's how long it takes sometimes to process by the FDA. And the warning letter will spell out exactly what the inspection consisted of. If it was perhaps an underage person who managed to purchase a tobacco product from your retail outlet, obviously while being undercover. It could also describe a situation where a person who was under 26 years of age, for instance 25, that maybe to your retail clerk they looked older, and therefore the retail clerk did not ask for verification, for age verification. But if that person in fact was not asked for age verification, that also would constitute a violation. Of course, the statute and also FDA's practice to date provides for different steps that normally start with a warning letter, enforcement steps that normally start with a warning letter and can escalate all the way to a no tobacco sale order, depending on whether the violation is egregious or repeated and so on. And again, the warning letters that have been issued by FDA in the past are actually quite helpful to review. If you're interested to know how FDA regulates, or I should say how FDA inspects manufacturers, there is a database of documents that are basically the result, or as it is called, the Establishment Inspection Report of tobacco manufacturers that FDA has inspected to date. And that database is also to be found on FDA's website. The Establishment Inspection Reports, or EIR, will help you understand what FDA is looking for in a manufacturer facility inspection. And it will help you also understand how to prepare your facility for inspections better. Certainly, vaping products are very different than conventional tobacco products. Conventional tobacco products are essentially an agricultural product, and vaping products are manufactured generally in a lab, and therefore, of course, there will be different things that FDA is going to scrutinize in connection with vaping products manufacturing. However, the establishment inspection reports issued to tobacco manufacturers in the past, again, are a good starting point. You'll also notice that in those reports, things that are confidential to the manufacturer, such as certain details of the manufacturing process, are basically edited out, obviously for confidentiality and reasons of trade secret. So certainly when FDA shows at a manufacturing facility, you can rest assured that that they understand confidentiality. In fact, FDA is inspecting all kind of other industries as well that certainly have information that represents trade secret in the past, and certainly it knows to preserve that trade secret. In brief, I believe we are going to experience a flurry of FDA activity. We expect FDA to issue more guidance documents. Certainly we expect FDA to react to the litigation, and therefore it is always a good idea to engage with the FDA through the Q&A email address and telephone numbers that FDA has provided. Really, FDA are the authoritative source of information for the regulated industry. It is also a good idea, as I indicated before, to review the tobacco products section of FDA's website for past activities. Also to monitor the guidance section of FDA's tobacco products website, because in that section there will be further guidance, as well as the news section of the FDA website that pertains to tobacco products, because in the news section, FDA will announce upcoming free webinars for retailers, small businesses, and certainly it would be a good idea to dial into those webinars. Most past webinars are available for replay on FDA's website. In conclusion, with respect to the website, it is certainly very important to know that you know, our industry is made up of generally micro and mini enterprises, as I like to call them. Some companies such as ours, such as Nicopure Labs, are of course larger and have more resources, but certainly it is clear that the vast majority of the industry, including the retailers, are very, very small enterprises, and generally FDA should have resources available for those kind of enterprises, and we expect obviously again a flurry of activity emanating out of the FDA in the next few months.
All of this what you expected, or are there any surprises out of the deeming rule?
Yeah, that's a very good question. We at Nicopure Labs were not surprised by the deeming rule. We were disappointed, but not very much surprised, because certainly we anticipated the direction that FDA may take based on the following things, based on their proposed rule that was issued in 2014, and based on bits and pieces of statements that various FDA officials have made over the last 2 years in connection with the regulation of our industry. Certainly they pointed in the direction that FDA may go. It is certainly a a surprise in that the deeming rule comes very shortly after a prominent report by the Royal College of Physicians that discusses the comparative benefits of vaping products compared to conventional tobacco products, as well as other information in that respect. Certainly, we as a company have prepared for this for a very long time. We have the expertise, we have the experts that have been guiding us to prepare for this moment in various ways. And we certainly are better positioned than most in the industry to face all the necessary challenges, but also to be proactive in leading the challenges, if you wish, for the benefit of the industry. More importantly, because we understand FDA regulation, probably much better than many others, we understand how complex and complicated it is and how every retailer and every manufacturer is unique. Their sets of products are unique. Their retail facilities are unique, and therefore FDA regulation will apply certainly the same for everyone, but it will depend very much on how you manufacture a product, what you manufacture, where you manufacture it, and so on. And therefore, we strongly advise retailers and distributors in particular to reach out to FDA for guidance, and also to work through trade associations to obtain legal advice if legal advice is not affordable to them, that is specific to each retailer's individual circumstances. Thank you very much, and stay tuned in the future for future webinars discussing important matters, important regulatory matters for our industry. Thank you.